Welcome to everybody. Good afternoon, good evening, wherever you are. For those who do not know me, my name is Matias Gonzalez Mama, and I have the pleasure of moderating today's conversation. I coordinate the Legislative Observatory at CELE. We're here to discuss a set of questions that sit right at the crossroads of law, technology, and society. As the title says, are content moderation policies protected as expression? Or put it in another way, when platforms moderate content, are they simply enforcing rules, or are they exercising freedom of expression of their own? These issues have taken on new urgency with the recent Google v. Russia ruling at the European Court of Human Rights, which drew new attention to the role of online platforms and the limits of their responsibilities. As some of you may know, the court reaffirmed that forcing a platform to remove or host content under threat of penalty interferes with the platform's own right to freedom of expression. I will not go into further detail here, as one of our speakers, Joan, today will address this point. But some of the questions raised are as timely as they are as complex. What actually counts as an intermediary when we talk about expression online? Should platforms' moderation policies be understood as exercises of freedom of expression? If not, should they be? Could companies themselves be recognized as right holders under international human rights law? And how do those rights intersect or collide with the duties and growing obligations imposed on platforms in the name of safety, care, due diligence, integrity, and accountability? So today we will approach these questions comparatively, looking at how the European Union, the United States, and Latin America have been navigating them, while also paying attention to emerging approaches in Brazil, which has become a laboratory of sorts for digital regulation, as some of you may know. So to guide us through this debate, which is very interesting, we're fortunate to have three outstanding experts. Joan Barata, who is a visiting professor at the Faculty of Law, Catholic University of Porto, Portugal. Eric Goldman, Associate Dean for Research and Professor, Santa Clara University School of Law, and Agustina Del Campo, our Director of the Center for Studies on Freedom of Expression, which is organizing these events. Each of them will have around 15 minutes to share their perspectives, and after that, we will open the floor for comments and questions, maybe first among the panelists, but then we will open the floor for the audience. So this is a rare opportunity to have such a comparative, multi-jurisdictional discussion in one place, and I hope you'll find it as engaging as it is important. So with that, let me turn it to our first panelist, beginning with Joan. Then I will give the floor to Eric, to Agustina, and then finally to Eric. Thank you.
Thank you, Matthias, and thanks to CELE. I feel a bit responsible for this. This event, because I remember that at some point I shared the decision with, I think it was with Matthias, and then we discussed it briefly via WhatsApp, and we said maybe we should organize something a bit bigger to assess the implications of this decision that is a very recent one from the European Court of Human Rights. So let me share my screen, which I hope that now you are seeing. And well, the question is, are content moderation policies protected as expression? And basically, I will elaborate a little bit. I'll analyze the case of the decision with regards to the case of Google and others versus Russia, issued by the European Court of Human Rights just a couple of months ago now. So I think that here we'll be talking, or at least, from an European perspective, this is a decision that is important or is relevant to reflect about two main issues that are at the center of platform regulation debates in Europe and probably beyond. The first one is, when is it justified to require an online platform to remove content or accounts, and what limits and safeguards should be observed? This is a discussion that, for example, was central in the process of the elaboration of the Digital Services Act in Europe. But we also know that, for example, in Brazil, discussions around the constitutionality of Article 19 of Marco Civil have also been touching on these matters. The second one is also a very relevant question, which is, can states force a platform to leave up content to allegedly protect the right to freedom of expression of their users? This is a discussion that it has become more and more important within the European context for many reasons. One reason is the fact that the Digital Services Act, for example, contains an obligation for platforms to respect the right to freedom of expression of their users. And we still are assessing or trying to understand the practical implications of such a provision. But also we know that in different countries, for example, in Germany or in Italy, lower courts have decided, in some cases, have imposed on platforms the obligation to live up or to reinstate content or accounts that had been taken down, that hadn't been blocked. So, I think that this is also, a very important discussion. I would say from the very beginning that the decision of the European Court of Human Rights gives us the opportunity to reopen these questions, perhaps to add some elements to the discussion, but it does not bring clear-cut solutions in each case. No, it just more material, more food for thought, but we will still need to wait for further decisions from the European Court of Human Rights to clarify some aspects related precisely to these matters. So the case refers, first of all, I think it's very important to mention that the case refers to Russia. Russia is a state that is no longer a member of the Council of Europe, and Russia is a state that it is no longer under the jurisdiction of the European Court of Human Rights. And I think that this is not just a mere anecdote. The case was decided because it was still pending. The case had been submitted to the court while Russia was still a member of the European human rights system. But now, the situation, the decision was adopted when Russia was not a member anymore. And the relationship between the court and the Council of Europe with Russia has always been very difficult. Russia has always refused to accept, to properly implement the decisions of the European Court of Human Rights. And in some cases, just to illustrate the situation, Russia has prosecuted lawyers who had brought in the past cases against Russia before the European Court of Human Rights. So, and we can see, I will further reflect on that this particular situation and the particular nature of this country, also has an impact on the way the court sees and assesses this case. This is a case about two main facts. The first one is the fact that the telecommunications regulator called Roskomnadzor, the Russian regulator, made a request to YouTube to block specific content and channels on the grounds that they contain socially significant disinformation and calls for extremist activities. While YouTube accepted in some cases that the content was illegal and it required to be taken down, most of the content was kept let's say available to Russian users, and this non-compliance led to escalating fines calculated on the basis of Google's global revenue. But also there's another series of facts that is connected to this case, which was the refusal from Google, from YouTube, to reinstate the Gmail and YouTube accounts of Tsargrad, which is a television station, a Russian television station that had been sanctioned by the European Union, the United States, and Canada, previously sanctioned within the context of the sanctions against Russia for the illegal invasion of Ukraine, of part of Ukraine. A commercial court of appeals in Russia decided in favor of the claims of the television stations, and access to accounts was restored by YouTube, but YouTube did not allow these television channels to monetize their social media accounts. This was seen as a failure to comply with the court order. other Russian state-owned and affiliation television channels filed copycat claims to obtain similar decisions from the national court. And I think it's very relevant that, considering, let's say, all the non-compliance coercive sanctions, at the time of the claim before the court in Strasbourg, penalties had accrued the amount of 16 trillion US dollars. 16 trillion US dollars. Of course, Google filed bankruptcy, and from the Russian side, the excuse that was used to legitimize such a crazy amount of money was that they had calculated the fines, to the amount to be paid, on the basis of their global revenue, not their business in Russia in particular. So these are the main elements of the case. How the court decides? Well, when it comes to forcing Google to take down content, the court reiterates something that has been saying in different decisions. It says that any measure compelling a platform operator to restrict access to content under threat constitutes an interference with the right to freedom of expression. Because Article 10, and this is a very well-known jurisprudence, protects both the content of ideas and information, but also the methods of their dissemination. And therefore, any restriction on those methods interferes with the right to receive and impart information. It's true that this instrumental protection of the right to freedom of expression was particularly expressed with regards to traditional means to disseminate information: radio, television, newspapers, etc. And here we are talking about a different type of entity and intermediary that is also, of course, considered as an instrument. However, the court says a few things that are of particular interest. The first one is that the significance of YouTube relies in its role as a forum where users can share diverse viewpoints on matters of public interest, including those that might not find expression in traditional media. So the court describes intermediaries as some sort of a forum where users can share content, and therefore where the right to freedom of expression can be exercised by different types of individuals. Something that is even more interesting is the fact that at some point they say that when internet intermediaries manage content available on their platforms or play a curatorial or editorial role, including through the use of algorithms, their important function in facilitating and shaping public debate engenders duties of care and due diligence, which may also increase in proportion to the reach of the relevant expressive activity. So the court seems to say that intermediaries do not only have rights, should not only be protected as instruments for the facilitation of the exercise of the right to freedom of expression, but also in cases where they curate content, where they recommend content, where they use algorithms, these intermediaries can be subject to certain duties of care and due diligence, duties of care and due diligence that are not described by the court, but some references to the Digital Services Act, which of course is not a source of international law, are made as an example in this sense. So this decision, if I might put it this way, is slightly different from what the court says in Delphi, because here in Delphi, the nature of Delphi was a platform, online news platform that had an editorial component, but also allowed users comment. And in this case, the court established that Delphi had certain obligations when it comes to the content posted by users. But again, this was not exactly a platform like YouTube, Facebook, etc. And also, this is also slightly different from the decision of Sanchez versus France, where the court said this was a case of a politician who had an account on Facebook, and some people started publishing nasty comments and in some cases illegal content or as comments to the profile. And the court said that that user, since it was an important user, a popular user who had an account that he was using to promote his political ideas, should have been more diligent in curating the content, the comments posted by his followers. So again, this is not exactly a social media platform, it's a user of a social media platform. So in this case, I mean, well, again, we're talking about something slightly different. But in any case, I mean, the most important conclusion from the court here is to say that penalizing Google for hosting content critical of government policies or presenting alternative views on military actions without demonstrating a pressing social need for its removal strikes at the very heart of the Internet's function as a means for the free exchange of ideas, of information. So basically following, let's say, the necessity standard that is part of the three-part test that the European Court of Human Rights applies, it establishes that this restriction, this obligation, the imposition of an obligation to Google, to YouTube to take down content is not necessary in a democratic society because no pressing social need has been shown to the court, has not been shown to the speakers in order to justify this kind the adoption of this kind of measure. What is important also is that here the court is, of course, referring to the impact that this may have as a restriction to the right to freedom of expression of the speakers, but also it considers, in this case, that Article 10 has been violated also when it comes to the rights of Google to freedom of expression, consisting of their capacity to moderate content. And here, I believe that also the principle of proportionality played a fundamental role, because remember, here we are talking about sanctions of 16 trillion euro, which, I mean, by no means would meet the principle of proportionality that, as we know, it is key in the analysis, in the assessment of the court of any restriction to the right to freedom of expression. Perhaps a little bit more interesting is the doctrine or the way the court analyzes the fact that Google is forced to reinstate the account of users, this television station Zargrad. It says very clearly that coercive measures against Google directly impacts Google's right to determine what content it was prepared to host on its platform. So the court clearly establishes that Google has, under Article 10 of the European Convention on Human Rights, the right to determine what content is prepared to host. And therefore, the court considers that this right falls within the scope of Article 10, as I said, which protects, again, not only the content of information, but also the means of its transmission. It's true, however, that restrictions can be justified in some cases. So even if we say that forcing a platform to host content may affect the right to freedom of expression, the question that we should ask is, would it be possible under Article 10 to consider a case where, I mean, this imposition, the forcing a platform to leave up content, it would be something legitimate. And the court seems to contemplate this scenario because basically at some point it says, well, I mean, the Russian authorities pretend that this is legitimate because they are saying that they are protecting the right to freedom of expression of the television channels. So Russian authorities are saying we want to protect the right to freedom of expression of the television channels, and therefore, I mean, this restriction is legitimate. And here the court is very dismissive. And we need to understand that here we're talking about Russia, and this is why it's very dismissive. And basically the court says, I cannot believe you. On the one hand, you are forcing YouTube to take down certain pieces of content. You are clearly violating the right to freedom of expression. And at the same time, you are telling me, you want me to believe that you are committed to the protection of the right to freedom of expression, and this is the reason why you wanted to impose on YouTube, let's say, the hosting of these television channels. I don't buy it. I don't accept this. Russia, you cannot tell me that you want to protect freedom of expression. Well, the question is then, if this had been a different country, if the purpose of protecting the right to freedom of expression of the user had been presented in a better or more substantiated way, would the court have decided in a different way? There are even some commentators that say that the court missed the opportunity to properly assess the legitimacy of, let's say, the fact that these television channels were legal or illegal. No, this declaration by the court that they were illegal, because these channels had been sanctioned many years before. The decision of Google. No, so to what extent this sanction, had to be seen just as valid without further analysis. No, that is, well, a question mark that I see here. But the case is that the court is very straightforward here. It says, Russia cannot tell me that they want to defend the right to freedom of expression when Russia is systematically violating the right to freedom of expression. So I'm not going to discuss in a serious way the legitimacy of the measure. And therefore, also, if I consider the fact that you are imposing these absolutely disproportionate sanctions for not hosting the channel, there's nothing else we should talk about. No, the problem in terms of proportionality is so important, is so relevant, that there's no need to further discuss the matter. No, this is a violation, a clear violation of the right to freedom of expression of YouTube, because you are forcing YouTube to, let's say, to host channels without their let's say, their willingness. So to finish, because I think you want me to finish.
Yes, yes.
No,
not to finish, but just to move on, so we can definitely go back to this again.
Yeah. Not just a few open questions, just to conclude. No, the first one is that, some people have questioned, is the court paving the way towards the recognition of a right to a public online forum? Because some parts of the decision of the court may suggest that. And as a matter of fact, the concurring opinion by Judge Pavli seems to suggest that the court needs to go further than that. But we have Appleby, that is a decision from the European Court of Human Rights that applied to a physical space. They say that there's no right to the public forum. Which kind of duties of care can be imposed on intermediaries? The court mentions duties of care, but it is not clear, what kind of duties of care would be compatible with Article 10. Who has standing to complain of an interference with means of dissemination? The user, the provider of the means, both. And also, of course, the big question here is whether the court might be tempted to move towards the recognition of a horizontal effect when it comes to the right to freedom of expression. Will the court accept in the future claims on grounds of Article 10 against private company for the removal of content on the basis that this constitutes a violation of the right to freedom of expression? I think that these are the questions that are left open by the court, with some elements of interest, and I think that they show that the debate has only started in Strasbourg when it comes to these matters. Thank you, and sorry for I wanted to be precise in the description of all the relevant elements of a case that is a bit complex, even in terms of trying to sometimes to properly understand what the court tries to say.
No worries. Thank you so much for that explanation and summary of the case. So I will give the floor to Agustina, and then to Eric. Agus, you have the floor. I will let you know when we're about 15 minutes. too.
Great. Well, first, thank you so much, Mati and Joan, for putting this panel together and for coming up with the idea and for inviting me to be part of the discussants here. So the case is truly complex, and I think it touches upon a number of different issues that could be the subject of many, many one-hour talks separately. It touches upon mandated speech. It touches upon intermediary liability. It touches upon editorial liability. The amount of questions that can be raised from this case that Joan just summarized for us, and that the court decided in a quite short decision, where it chose to focus on a very limited aspect of these complexities. But I think the most interesting thing to me, at least from a Latin American perspective, is that it goes back on the question of what is an intermediary, and whether an intermediary can have editorial freedoms or whether an intermediary cannot have editorial freedoms. And historically, we have spent almost 12, 15 years discussing whether the difference between Section 230 of the United States and the European Directive on e-commerce was precisely the editorial discretion or not. Section 230 establishes that internet companies are not going to be liable for third-party posted content, and they are not going to be liable for acting upon content that they think should be acted upon. And it promotes self-regulation exclusively, and the jurisprudence that came afterwards practically grants absolute freedom to companies to decide what content they host and what they take down under this big umbrella of Section 230. And the European e-commerce directive has a conditioning word that says neutral intermediaries. And we spent thousands of hours discussing, what does neutral mean? Does neutral mean that you have intermediary protections as long as you're not curating speech? And is that even possible? What is what is an intermediary regime without a curation regime, right? Every decision that you make regarding the way in which you display content, order content, whether it's chronological, whether it's by relevance, it entails a decision that is by no means neutral. So I think the case reopens a little bit this discussion. Are we considering intermediaries, or are we thinking about this in more of an editor's kind of role? Are we thinking of intermediaries as actors that can have their own freedom of expression separate from an editorial role or separate from their intermediate role? I think that question is pretty relevant for a Latin American perspective. And what I'm going to try to do very briefly is paint a broad picture about inter-American law and about comparative constitutional law in the region very, very broadly, because I have like a minute and a half to do so. But I'm going to try to do that, and then we're going to save the buts and the nuances for the discussion, if that's okay for everyone. So from an inter-American perspective, the chances of a similar case arising at the inter-American level are probably null. The inter-American system has not recognized companies or judicial legal persons as subjects of human rights law. And unlike the European Court of Human Rights, that has a separate addendum to the convention that allows for legal entities to be part in proceedings before the European Court. The Inter-American system has nothing like that. The way that traditionally, historically, the Inter-American system has approached this was by recognizing the human rights of those involved in the companies. So when it was media conglomerates, they addressed the editorial rights of the senior editor or the owner of the newspaper or the people that had actions in or bonds in the companies that whose rights were being violated. It has, though, recognized the duty of the state to take action to prevent and investigate potential human rights violations. So one of the things that we in the region have been discussing for a while was what could the state's liability be for not regulating social media if social media is breaching human rights? Can the state be liable for not preventing or investigating or regulating so that companies respect human rights? That is something that we have been discussing, and that is quite linked to a constitutional way in which we see rights. Human rights in most countries in Latin America are viewed horizontally. So companies, this is complex and it deserves another hour of discussion, but some rights and some duties of the state can be translated to other actors. The obligation of non-discrimination, for example, is something that it is not only the constitutional protection against discrimination, doesn't only protect against discrimination from the state, it also protects against discrimination from private individuals, companies, etc. The right to freedom of expression is recognized vis-a-vis the state, but also vis-a-vis some private parties and in conditioned settings, right? And that takes me to the second point that I wanted to make. Constitutionally, when you look at the constitutions, at most constitutions in the region, the rights of media companies and media conglomerates have been historically recognized. And when you look at freedom of expression cases, in most cases, it's the defendants are journalists, media conglomerates, and editors. And also the plaintiffs are also media conglomerates, journalists, and editors. So the rights to freedom of expression, the constitutional rights to freedom of expression, are a lot of times recognized for organizations and for legal entities as much as they are recognized for private entities. So I think this is the way that a lot of the courts in the region have addressed intermediary liability. Why? Because we don't have a Section 230 and we don't have a European e-commerce directive, and we don't have, for the most part, except Brazil, a specific law dealing with intermediary liability protections. So the way the different courts have attempted to tackle this issue is through civil liability, and in most cases, framing this issue as a freedom of expression issue. And they have addressed freedom of expression of Google, of Meta, of different companies. And although in most cases, they have ruled that the freedom of expression interests were infringed upon by the different cases, the truth is that most of these courts have been building potential scenarios where companies could be civilly liable, depending on their actions and depending on the conditions. And I'm going to cut it there. And I'm going to give the floor to the next speaker. Thanks so much.
Thank you, Agus, for that. Super interesting and very complex because Latin America is not a homogeneous region, so it's not easy. Eric, you have the floor.
Thank you. Can you hear me okay? Just checking my
Perfect.
super.
Yes.
Yeah, hi. Thanks for including me in this conversation. And it's really an honor to share some thoughts with you about not only the European case, but how we think about things in the United States. And honestly, my remarks dovetail quite nicely with Agustina's. I come at it from a different perspective that might reflect the US perspective, but I do want to stress I'm happy to talk about Section 230, but much of what I'm going to focus on relates to the Constitution and the First Amendment, that we don't even get to the Section 230 statutory provisions because the Constitution kicks in and applies to the issues. And I think that Agustina did a really nice job about framing this balance between thinking of internet and players as publishers or not. And if they are publishers, there is no conflict between the rights of the publishers and the rights of any authors who reach the publisher's audience through the publisher. We have centuries of case law in this area that make it clear that the publisher decides what to publish and what's fit for their audience, and authors have no way of overriding that judgment, nor do governments. That is purely within the author's, within the publisher's standpoint. So looking at the European opinion, where there were fines for publishing content that the government objected to, that was, if it was constitutionally protected content, that's just censorship. And we would call it censorship, and it's an easy call. The government's not allowed to do that. Similarly, when it comes to obligations of the publisher to publish things they don't want to publish, what we call must-carry obligations. Must-carry obligations in general also override publishers' discretion, also not permitted by the First Amendment. These are, again, venerable traditions. So what's been going on, and Agustina, I think, said that there was thousands of hours spent debating the issues. What really has been going on for the last 15 plus years is a broad-based global effort to try to say that platforms, internet services allow people to talk to each other. User-generated content services don't qualify as publishers. We shouldn't think about them as publishing content, that there's some other legal status that allows us to then ask the questions, are the users uploading content really the authors / publishers who have protected rights, and the services in the middle of that conversation have no control over what authors would say to their audience. And factually, the facts are obvious, at least here in the US, that many of the services that we would describe as platforms have editorial control over the content that is disseminated through the system. They have editorial rules. They have editors who are exercising those editorial rules. They do everything that we expect from publishers who get the First Amendment protection. So from a fact standpoint, honestly, I think there's not a lot to debate. But from a legal characterization, there's been lots of debate over these questions. And the whole goal has been to circumscribe or take away power from publishers to decide what's fit for their audiences. And I would contextualize this as a broader, actually a much broader effort across the board, online and offline, to ramp up the degree of censorship in our society. And when we started in the 1990s, there was this hope, maybe utopia vision, maybe this naive pie in the sky fantasy that the internet was going to somehow be censorship resistant or censorship proof. And we're seeing the exact opposite, that the internet is actually increasingly under the control of the government in a wide range of ways. And the internet is morphing or mutating to actually try to optimize in this era where the government is dictating many aspects of their operation. I think that the Russian example is an extreme example, but frankly, I'm not sure how different it really is from what's going on in other countries as well. It might just be a matter of degree. In a sense, all of our countries that we are represented on this call have to ask the question, are we actually qualitatively engaged in a different process than Russia engaged with YouTube in this case? It's really, I think, a disquieting view for someone like me, a long-standing internet guy, to see how much the censors are winning the battle across the globe, across the internet. Some of it's the outright censorship, like what was taking place in Russia. There was really no question. That was just flat-out censorship. A lot of it has also been this jawboning that we were talking about in the U.S., where the government is telling the services, the platforms, what they want them to do, but not making it an absolute requirement with fines. It's kind of the mobster type approach. It would be a shame if anything happened to your business. Here's what you can do to avoid that. And we're certainly seeing here in the U.S., but I think it's across the globe as well, what we call working the referee. For those of you know this in football, someone who doesn't like a referee's call, they protest it. They're not hoping to change the referee's call on that instance. They're hoping to get the referee to make a different call on the next instance. And we're seeing that over and over again, where governments are using all the tools in their power to work the editorial judgments of the online publisher / platforms to get them to do something more favorable for the government, without the outright call, but just knowing that by using the specter of carrots and sticks, that they can get different outcomes. I will flag that I am petrified about this issue with respect to generative AI as well. We are seeing the exact same battles taking place in generative AI. Unless we establish that generative AI outputs are protected expression, then the governments are going to run roughshod over that as well. And we're already seeing that here in the US, where government actors are taking partisan positions about generative AI outputs, saying the generative AI outputs must address content in a certain way or cannot address content in a certain way. Again, exactly what the Russian government was doing to YouTube, but they're doing it for generative AI. And unless we come up with a conclusion that says that generative AI outputs are the output of a publishing process that gets First Amendment protection, it's toast as well. I'm going to wrap up with just a couple of final thoughts. I mentioned that censorship is the censors are winning across the globe. I think it's a related phenomenon, but I'm seeing basically the retrenchment of the importance and honoring of due process, retrenching across the globe. Due process is on the run in all circles, and it comes up in things like questions about forcing internet services, publishers, platforms, whatever you want to call them, to remove content. So, for example, here in the U.S., the government enacted the Take It Down Act, which basically gives a heckler's veto over certain types of content as a way of bypassing any court review. Basically, the carrots and sticks are that if a service receives a Take It Down Act takedown request, there's only one outcome. You're going to take it down without any due process whatsoever. And we're seeing that across the globe, across the internet, this idea, like, we don't need due process for creating legal obligations or rights that involve the removal of content. We can just force it through other means. I will reiterate that the European opinion also really raised squarely for me this question about rules versus standards. When do we need hardline rules about what content is permissible or not permissible? And when are we going to make that judgment based on standards? And I don't love Article 10 for the reason that much of it is basically a standard. in the opinion, there was this language, a pressing social need for removal. That's a standard, not a rule. Things like necessity and proportionality, those are standards, not rules. And the more that speech decisions are subject to standards and not rules, there's a risk that all the other things I mentioned, like the jawboning or working the ref, will end up causing the government to get its way and succeed with censorship without having a hard, without actually passing a law. So we definitely have the issues about when do we need rules that protect the publisher's right to publish. And that's what the First Amendment was supposed to be, but we're seeing that in retrenchment as well. But without a rule there, we're going to see more censorship, more censors winning because of the fact that the standards don't give the kind of legal protection necessary for the publishers to feel confident that they will be protected. And the last thing I'll mention is the Calvin ball problem. I trust many of you are familiar with the concept of Calvin ball, but I will mention it. It comes from the comic strip Calvin and Hobbes, one of the most cherished comic strips of all time. And there was a young boy and his stuffed tiger who came to life in his mind, and they would play games with each other called Calvin ball. And there was only one rule of Calvin ball, which is that they could never play the same rule twice. The Calvin ball is the opposite of the rule of law. The rule of law is that there's predictability, that there's rules published in advance that everyone knows that are equally applied fairly, so that everyone knows how to follow the rules. Calvin ball, you never play the same rule twice. There is no rule of law in that type of approach. And as you may have seen, courts in the US are acknowledging that the opinions that are coming out of the Supreme Court and elsewhere are Calvin ball opinions. I felt like the Russian government was playing Calvin ball with YouTube, that they were changing the rules as they went along each time to get whatever they wanted. But we're having that same Calvin ball taking place across the globe, that the rule of law is dying, and as it dies, speech dies with it. I'll stop my remarks there.
Thank you so much, Eric. Super interesting. There are a lot of things to pick and to discuss. I just want to give you guys the opportunity, if you want to react to one another, and then we can open the floor, just in case you want to say something. I think that would be very interesting. And then I will give the floor to Eduardo, who has raised his hand. I don't know if you, Agus or Joan.
I do. I have a question for Eric. Actually, I share a lot of what you've said, actually. But to be quite honest with you, I've had a hard time finding American scholars discussing company liability under First Amendment law and not under Section 230. And I mean, one of my ongoing discussions with some American scholars was, well, you cannot claim Section 230 for some pieces of the conversation and then argue First Amendment for editorial protection. So you cannot have it both. You need to pick. Either you are an editor and you have the protections and the responsibilities of an editor, or you are an intermediary and you have the protections and the responsibilities of an intermediary. And in many cases, I feel like that discussion is still ongoing in the US. And I think the mix can be problematic when trying to all sit together and agree on what is the issue that we are discussing. So I wanted to ask whether your position, when you say, okay, so we need rules, which rules do you think are the ones applying? And when you propose an analysis from the First Amendment, are you proposing editorial protections and responsibilities for intermediaries?
Okay, so thanks. Really important question. And I'm going to oversimplify it just because I do know that we'll want to get through some other questions. So we start with the Constitution. Our internet services publishers, for purposes of constitutional analysis, do they receive full First Amendment protection? And that's something legislatures can't override. That's solely a function of how the courts interpret the constitutional requirements. And for example, in the Moody case from 2024, the court said, yeah, of course they're publishers. It's really not a closed question. And then since then, we got two rulings, the TikTok ban and the age authentication imposition, that seemed like a significant retrenchment into that. But so long as we start with the premise that internet services are publishers for constitutional protection, they get all of the benefits of the First Amendment. Now, you said that those can come with some obligations, like liability for publishing content that creates harm. The legislature can amend that liability regime. Those liabilities are not constitutionally required. The legislature is free to decide that they're going to say, you get First Amendment protection, but we're going to also give you some extra benefits from a liability or damages perspective. Legislatures do that all the time. I call them speech-enhancing statutes. Section 230 is in that category. So Section 230 and the First Amendment are not in conflict whatsoever, because we can say that from a constitutional standpoint, the services are publishers, but from a statutory standpoint, the legislature has decided that the rules might be different for certain types of publishers than others. Now, we did get an opinion. I've lost track of the years. I want to say 2024, but maybe it was earlier than that. I can't remember. Where in one circuit in the US, the court said you have to pick. If you get the protection of the First Amendment, you cannot qualify for Section 230. And if so, that's a really powerful conclusion, because we already said that internet services are publishers, and it's not a closed question. So then what the court is saying is no Section 230 for any of those. They basically repeal that statute. Other courts have not been agreeing with that. And so we're seeing the battle you're describing playing out exactly as you're describing right now, as courts are trying to wrestle with that question. Can you be First Amendment protected as a publisher, but still avoid liability because the statute gives you that permission to do so?
Thank you for that interaction. I will give the floor to Eduardo and then to Courtney, just in case they have a question for Eric, who needs to leave it in a few minutes.
Okay, can you hear me?
Yes, perfect.
Okay, great. Well, thank you very much. Thanks for organizing these high quality events as usual to CELE team. It's a pleasure to attend your meeting, guys. I have questions and brief comments. I will be very brief, no worries. One is some sort of clarification to Joan. If I understood you, Joan, correctly, you said something like the court in the same case was using the actions of Russia in other cases. I mean, I want to understand. I mean, if the European court is using how Russia act in other cases to sustain that there is no violation, or there is a violation of Article 10 in this case, or it was all the same case, because that will be new for me, that they are saying, okay, come on, do not say, now you, Russia, cannot say that you are supporting freedom of expression, because in the other case, you are not supporting freedom of expression. It's just a clarification to understand what they are saying. Going to Agustina comments or presentation, I would say, yes, I mean, sometimes I feel that I am in a tunnel going back to the past, because we were discussing about intermediary liability for years. I mean, when I was at CELE, we published something specifically on intermediary liabilities, and one of the answers there that we cannot say, I mean, we need to divide intermediaries in different groups. Not all intermediaries are the same. So maybe when we are thinking about regulations, we need to think about regulation for particular intermediaries and not for all intermediaries, because intermediaries, depending on how we define them, could be, the telephone company with the Cooper cables, and different thing is a hosted company that hosts content. A different thing could be a platform that offer things to sell. So it's complicated, and I see that we are still discussing that. But going to I think that you always has a little bit pessimistic view about the Inter-American system. You are absolutely right saying that for now, the Inter-American system is not allowing standing for corporations as subjects to be suffering violation on the convention. I agree with that. But it's not that clear. There are some cases, some situations in the past that was discussed. I was special rapporteur when we discussed, precautionary measures that benefited a company in Venezuela that was Globovision. It was a very important discussion there, and the thing was exactly what you said, if they have standing to be protected by the convention or not. So it's complicated. But what puzzled me more is the wording of Article 13.3. When the convention talk about, indirect means for violations, they say, for example, the import of or the restriction to import ink or paper or something like that. That is very clear that the people who drafted the convention, they were thinking in companies, in press companies. They were not thinking in individuals. So we as advocates can develop an argument saying that in the Inter-American system, we also have that possibility. The other thing is, so one side of the coin is if companies has standing to be considered subjects that suffer violation of human rights. The other side of the coin is when companies are blamed to be, the perpetrators of human rights violations. This is the other side of the coin. And you, Agustina, were absolutely right as well. I mean, there is a literature that we can frame under the title of non-state actors and saying, okay, states has something to do when non-state actors are doing wrong or are violating human rights. And it's very interesting because in the last advisory opinion coming on climate change, very recently, advisory opinion 32/25, the Inter-American Court of Human Rights was very, very clear about this idea that the state has a responsibility when they are not doing anything and they know that a private corporation is, in this case, polluting the environment. So we can say exactly the same with freedom of speech. If the state knows that there is a private corporation violating Article 13, the state has a duty to do something. But here is the dilemma for me, and I open the floor I open for you guys to have a new discussion. The dilemma for me is that on the one hand, we are saying, okay, your state, you could be fined, you could be a violator of the convention if you are not doing anything to stop that violation coming from the private sector. And then when the state regulate, we are saying, okay, but you are regulating and you are violating Article 13. So how is the regulation is the problem? I'm not saying anything new, but there is a dilemma there because we are pushing the states to do something, but when they do something, we are saying you are a violator of Article 13. And that dilemma, I would like to say, I agree that you invite us to have this meeting under the title of content moderation. In the same way that in the past I said that we have to abandon the wording of right to be forgotten because there is no thing as right to be forgotten. Now I propose that we have to abandon this idea of content moderation because it's an euphemism of censorship. And I'm going to Eric, and I finish this. I really like your question about how much censors are winning this battle, because I think that we are in a real problem now with that. And the two things: one, the necessity and proportionate things. Yes, there are standards, there are no rules, there are principles. I think that Jason says something like that in the chat, but they are the thing that they use. The court used for doing interpretation of the regulations that the states are passing, but we can expand on that. But my final question, and it's another question to Eric, is yes, we were talking a lot about sections 230. I attended many meetings here in the US that 230 is contested now. I'm not sure if Section 230 will survive in the future. But in terms of going back to intermediary liabilities, we are not mentioning the DMCA. The DMCA has strict rules for intermediary liabilities, in my view. And we are not putting the DMCA in the same conversation, and maybe we should, and probably the answer is, well, it's not related to First Amendment. I don't think so, but this, I want to stop here. I talk a lot, sorry.
Thank you, Eduardo. Do any of you want to answer Eduardo's questions, react to them? And then I give the floor to Courtney.
Yeah. Thank you. Two areas. The first one is that, I mean, this contradiction. I mean, the court accusing Russia to be contradictory. This is within the same case, because, as I mentioned, the case has two aspects. The first aspect is Russia forcing a platform to take down a piece of content on the basis of, let's say, a series of reasons that are not considered to respond to the idea of legitimacy by the court. And then the second part of the case has to do with Google refusing to leave up content. So it's within the same case. And the court says, here in this same case, we are discussing first that you, Russia, wanted to take down a huge amount of content, which is clearly a violation of the right to freedom of expression. And while at the same time, you claim that the fact that some Russian channels were not reinstated by YouTube is a violation of the right to freedom of expression. And that, the court says, this is a contradiction. You cannot be, I mean, violating and defending the right to freedom of expression at the same time. I think that, as I said, I think this is a poor argument, because also, I mean, when it comes to the Russian channels, I mean, the court basically validates the fact that these channels had been sanctioned few years before. And that was already a valid reason for YouTube not to, I mean, keep them up. And that was enough. And there was no need for a further discussion in this area. That, I think, this is a problematic aspect of the decision. But indeed, I mean, something that was also has been particularly underscored by commentators is the fact that the court seems to, let's say, accuse, I mean, Russia of hypocrisy in this case, which is something that probably we wouldn't see in a different case with a different country. That's one thing. And something else that I wanted to comment on, the issue of responsibility of the state to protect freedom of expression vis-a-vis non-state actors. As you know, this was also part of an interesting discussion by lower courts in Germany, by the way of, let's say, accounts that had been blocked or suspended, and those, I mean, the individuals, the organizations went before the court, and the German court used the notion of the essential core of the fundamental right, which is a very German constitutional notion, saying the decisions taken by the platform, considering the role that platforms play in societies, and considering the impact that these decisions had on the right to freedom of expression of a private individual, touch so much the very essence of the right to freedom of expression that doesn't matter if this decision has been adopted by a private or a public entity, the necessity to the right to freedom, to protect the right to freedom of expression is there, and therefore the courts can intervene protecting the right to freedom of expression. So I'm not sure if this was clear, but for example, in the case law of the German courts, we have already found this kind of arguments in this sense.
Thank you, Joan, for that. Courtney, you have the floor.
Thanks so much, and apologies for being off camera, and if it's loud, I'm on my way to the airport. But I just wanted to suggest that, this bifurcation between, platforms as publishers or as intermediaries, I think we're often leaving out really valuable legal regulatory frameworks that could help us have a more nuanced discussion, I wish Eric was still here, because in the US, we have communication platforms such as broadcasters and telephone companies, which are, independent platforms and, have constitutional rights, but are regulated in a way that either imposes common carriage provisions or, other sort of regulatory frameworks, recognizing that either they are natural monopolies or that they play a role in the market, a dominant role in the market, or there's a public interest orientation. Many countries, including in Europe, in Brazil, and Japan, also impose requirements on broadcasters and other media that do have protected expression rights, that impose additional requirements such as, must carry provisions for certain types of locally produced content or linguistic content, or other types of things. And I'm happy to share a small report that we did on this for the OSCE that will be coming out soon. But it seems to me that we should be also talking about those types of regulations, not simply, do platforms have 100% free expression rights and exemptions from liability or not? And instead thinking about, well, should we be looking at alternative regulatory frameworks? And that's what Ohio, the state of Ohio in the United States, had tried to do with Google. Now, that was unsuccessful for the search case, but it's not fully resolved yet. So anyways, I just wanted to throw that out there. And I think Eduardo kind of alluded to that when he mentioned telephones. But I'd love to see more of a discussion about that, and for us to think through, like, what are the legal regulatory frameworks that could be extended where, yes, they have some level of expression, but you can impose requirements like must carry, like common carriage, like anti-discrimination, like restrictions on, data usage across, across different services or self-preferencing, etc.
Great. Thank you, Courtney, for that. I think, Aus, you raise your hand, and if possible, I would like to add a question I've been lingering on since this conversation started, which is, I see a divide between understanding or seeing companies as right holders, as entitled to a right to freedom of expression, and at the same time, I hear or see the possibility of protecting the activity companies carry out under the right to freedom of expression, because they are a means to an end, a means to the social aspect of freedom of expression. That's what I've read in some decisions in Latin America, and I think in Europe as well. Whether the question is, are they right holders in the same way as people, natural people, are considered right holders to a right to freedom of expression, or is it because of the activity they carry out that the activity is protected? Because the social dimension of the right to freedom of expression is protected. Because I think when we are talking about editorial rights, we're talking about the possibility of companies of deciding what they show, what they moderate, what they do not moderate, and stuff. And the possibility of not forcing them to say or not to say something. But at the same time, I also see the argument about protecting them as a means, which I think that's the part of the discussion that is connected to what Courtney was saying recently regarding the media, the regulation of the media. So that, I don't know if anyone wants to go in that direction.
Okay. Can I come in? Cool.
Please.
So I wanted to go back to Courtney's point and a little bit to Eric's point. I think the way you framed this conversation about whether the companies are intermediaries or whether the companies are editors has an impact on the way you can regulate them, has an impact on the way we define their rights, and we define their duties. And I understand it's unfortunate that Eric has gone, but maybe other Americans in the room can come in on this. Although I understand that the dimensions of constitutional protection are different from the dimensions of policy protections or legislative protections that may be speech-enhancing policies or laws, the discussion in the US has not reached ever a point of First Amendment discussion, basically because Section 230 preempts it. And there's a huge way in which the interpretation of Section 230 was construed that makes that happen. If you read Section 230 in a broader freedom of expression doctrine and legal setting, you can even understand from it that what it creates is a right to self-regulate, which is the same right that we have given media. Media, the way media publishes or doesn't publish, what they put in the front page or what they don't, how they abide by ethics or how they don't abide by ethics, we democratic societies have decided not to subject to state power. This is something that has been limited to self-regulation of the media. And I noticed Courtney said print media and not other media. But I think broadcast media is more regulated, but they still have a lot of freedom. They choose which are the news that they want to publish and which they don't. And the regulations are broad, are how, are when, but they are not what. They have allowed mandated speech in certain instances where they have reached a justification that the obligation to speak, that the must carry obligation is grounded in a democratic necessity, like the one, for example, that guarantees every party the right to advertise in primetime television. And you can mandate a broadcasting company to give space to every political party. And that has been found to be in conformity with First Amendment standards, even. Not recently, but in the past. So this is something that could be built into the whole thing. Now, I'm a little bit more concerned about how we distinguish this for the purposes of the state justification. If we keep thinking about the traditional distinction between intermediary editor, the way Europe has been doing, the way that Latin American has been doing this, we arrive at the conclusion that we can set on intermediaries duties of risk assessment and mitigation assessment that go beyond what the law or what the government can mandate through a law. But if we go through the editor's responsibility, then you can self-regulate and you will be held liable when your self-regulation infringes upon legally recognized and actionable rights. You know, there's a radical difference. In one, if you regulate through intermediaries and you are not editors, you're just promoting others' speech. And in promoting this, you are a public forum. The public forum analogy is the one that best fits that issue. Then you can create rules of risk mitigation that go beyond what is legally mandated. Now, if you find them editors or publishers, then there are strict rules in the laws of every state that clearly establish what they can be held liable for and what they cannot be held liable for. And the issues that they want to mitigate, not want to mitigate, the risks that they can take or not take are beyond the scope of what the state can have an opinion about. In short, I think the way we've come to the current state of affairs, where we have intermediaries subjected to more censorship than ever, has a lot to do with the legal framework that we selected to give them. We are fighting for freedom of expression in a private setting. If we turn the conversation again into a liability conversation, we are returning the conversation into the legal aspect and not ethics, risks, mitigation, or whatever else we might want to deal with. I'm not sure if that was clear. It's a very complex theory, but I just throw it here.
It was clear. It was clear, but complex. I think there's a question by Owen for Joan in the chat. I don't know if you got a chance to see it, Joan, if you want to answer it.
Yeah, thank you. Thank you. No, before that, I mean, just by the way of what you ask, Matthias, just a reflection. I think that the European Court of Human Rights in this decision and previous decisions opens the door to consider that, for example, when a platform is forced to take down a piece of content, this could be a violation of the rights of the speaker, of the user who posted that piece of content that is articulated in an indirect way, but the state is using indirect means to attack the right to freedom of expression. It can be also seen as a violation of the rights of the audience, the right to access to information of the other users of the platform. This is something that the case law of the European Court of Human Rights seems to suggest in some cases. And finally, and this is perhaps, I mean, where, I mean, this court decision is particularly clear and somewhat new, also the rights of the platform itself to decide what is acceptable, what is hosted by the platform itself. So this is the complexity of, and I think that we can find references to these three perspectives in the case law of the European Court of Human Rights, and also I think the concurring opinion by Judge Pablo is very interesting when it comes to particularly this reflection and these different angles that we can take when analyzing these kind of decisions. When it comes to Owen's question, that I mean, I had to read it twice or to I mean really understand, and I think I get what he means to say. I believe at this point, what I can say is that I mean it's true that the case law of the European Court of Human Rights now seems to protect, I mean, the right to freedom of expression of platforms, and therefore platforms' policies and decisions in many cases will be protected under Article 10. But it's true also that the court admits that in some cases, these platforms can be imposed by the state duties of care. The question is, what kind of duties of care here are we talking about? No? The duties of care of the DSA, or all the types of duties of care. And so far, I mean, if we look into the case law of the European Court of Human Rights, these duties of care seem to refer to the way platforms deal with illegal content. So when it comes to dealing with illegal content, detecting illegal content, responding to notices regarding illegal content, these are the duties of care that at some point can, let's say, justify the imposition of certain restrictions and even certain responsibilities to platforms. When it comes to duties of care that refer to content that is legal but harmful, I'm not sure. And I'm not sure that the European Court of Human Rights has expressed any clear position. And I think that this is what Owen had in mind. No? Basically, I mean, the idea that, for example, a platform can be imposed certain restrictions in the way they moderate content, not only to deal with illegal content, but also to promote pluralism or to promote good speech or good content vis-a-vis bad content. No? Here, this is an area that I don't think it is explored by the court yet, but I think that we need to differentiate. No, I mean, I think that at this point, the duties of care that the court would accept would be duties of care related to the way platforms deal with illegal content, as we saw, for example, in Sanchez versus France or Delphi versus Estonia. No? Just, I hope that, I mean, Owen can intervene if he wants to further discuss this matter, but I think this is what he was asking about.
Thank you, Joan. Are there any other questions, comments, reactions? If there are no further questions, we will be rounding up because I think it's quite late for Joan in Europe. I would like to thank everybody. I would like to thank the speakers. Thank you. Eric is not here, but thank you, Eric. Thank you, Agustina, and thank you, Joan. This was a wonderful discussion, a lot of food for thought, and I would love to continue this discussion. I think there are a lot of threads that we can pull and, you know, go deeper, I think. Well, thank you again. It was a pleasure hosting this meeting and looking forward to seeing you all soon.